What's up, everybody? Welcome back in to another episode of The Lawyer You Know. We had our final pretrial hearing before the trial starts for Karen Read next Tuesday, and a lot happened. Some really interesting arguments that were made, some really not great arguments that were made. I think kind of embarrassing things that happened, some maybe shows for the camera. And I'm going to give some of my first real thoughts on the Turtleboy situation with how it has to do with the Karen Read trial and what happened in court today regarding Turtleboy and what I think about that. Just some real opinions and thoughts on that, because I'm hearing some stuff on Twitter that I think is kind of weird, and like on the internet that I think is kind of weird. And it's probably because it is Turtleboy. We're going to listen to a bunch of the hearing that happened today, give our thoughts, opinions, how it's going to affect trial number 2, because we are rolling full speed ahead. So we started out this hearing with some things that are still before the judge, some decisions that she has to make about Mr. Wing, the expert, about Dr. Crosby. What will they be able to testify? What won't they be able to testify about? Will there be any more of voir dire? Will they allow these lawyers to question these witnesses before trial? It seems like she wasn't going to allow him to compare it to Chloe specifically and say this does or does not match up with Chloe's teeth, because like all the literature says that's not reliable. Hank Brennan gets up and tries to argue, Judge, exclusion is different than inclusion. Pretty terrible argument. Even his own people and even Adam Lally, I think, would disagree with that. I think the judge does too, unless he's like, no, Judge, the articles you cited, which are the scientifically appropriate articles, are correct. And no, we are not going to have a situation where he should be able to use this to exclude. So the judge took that under advisement and will make that decision. I don't think she made the decision. She definitely, gave us an idea of what she's going to do to allow Crosby to basically do everything except say this was not Chloe. I think the defense said the audio was not great in the beginning. I think the defense said they're going to use like a single picture in opening, which I find interesting. What is that single picture and what are they going to use it for? Is it the injuries to John O'Keefe's arm? Is it a picture of John O'Keefe and Karen looking happy together? I don't know. But the prosecution, on the other hand, is going to use upwards of 44 clips of Karen Read making statements. And they said they're going to whittle it down, but they're like, well, we need to know if the defense can object to any of these. It's like, well, we've got to review 44 clips right now to make all of our objections. That's kind of unreasonable. Like, what are they actually going to use in the time period allotted? So again, I think they're working that out together to try to figure out what exactly they are going to try and enter during opening, but still a lot of procedural and just kind of housekeeping matters that the judge is going to have to make a decision on between now and Tuesday. I expect a bunch of orders to come out over the next few days while there will be no court. Then we talk more about Karen Read's statements. And a lot of the questions were, are these statements going to come in? If they come in, what are they going to be used for? Will the defense fight it? Won't they have to lay a foundation? How is it possible these statements come in if the defense objects? Well, let's see that discussion. Does the defense object and why? What is their thinking behind their decision here?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for...
I think that's what they just said they're just going to give you.
We'll give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So, all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
So no objection to those Karen Read statements coming in. And everybody was, like, wow, what's happening when Brennan filed this motion? It's like, well, yeah, if the defense actually has an objection, but they're not going to say it wasn't Karen Read. They're not going to say she didn't know she was talking about something that would be recorded. They're not going to say that this isn't a defendant making a statement in a criminal case. They knew it was coming in. They always knew it was coming in. I said that from the jump. I probably wouldn't have done it. Not probably. I wouldn't have done it. But because they did it, these experienced lawyers always knew those statements could and would come in at trial. I have no idea why Lally didn't use any of them last time. He wasn't just creative enough to use them, I guess, but Brennan is going to use them. That is not going to surprise the defense. So when we talk about Karen Reed's statements, will the prosecution make some hay with them? I think they will. I think they'll be able to fit them into their angle of the case and theory of the case. But the defense will be able to make sure that they are given in the proper context. It's not just taking one word or phrase out of the entire interview. And if it is, they'll be able to add some portions for the rule of completion, the rule of completeness, to make sure these statements aren't taken out of order. Doesn't mean that they're out of context, I should say. It doesn't mean that they are going to be able to play the entire interview. But you have to remember, Karen Reed made these statements not on a witness stand, not with a prosecuting attorney cross-examining her and grilling her with documents and impeaching her and talking about maybe some prior inconsistent statements or whatever. She was able to make these statements with none of that happening to her. And so that is a good environment for a defendant to make a statement versus on the witness stand where the prosecution is going to be able to scrutinize her and grill her. So the defense knew that. That's the risk they took. They are not surprised at all. And it seems like they are not even objecting to those statements coming in. They always knew they were going to come in. But how are they going to be read to a jury? We're going to listen to this discussion back and forth. I'll tell you how I usually do it in my trial, what's usually found to be appropriate and what's not. And we'll kind of discuss what Hank Brennan wants to do in this case.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
So they want an independent reader, meaning some random person or somebody that they all agree on, to come and read the text messages at different points in time throughout the case. So when they want to put in a specific text message, they're going to have somebody come take the stand and read it as if they are Karen Reed. I would object to that. If the defense doesn't object, there's nothing inherently inappropriate about that. It is okay to do if everybody agrees. If the defense objects, I've never had a case where it hasn't been either an officer or a custodian of the cell phone records reading the text messages or a lawyer from each team. We have done that, where I'll ask a question and the defense lawyer in a civil case, if I'm asking the question as the plaintiff's lawyer and the defense lawyer takes the stand and answers it or vice versa. We have done that to make sure that neither of us are putting the wrong emphasis on the wrong syllable. Whatever movie that's from, I don't remember, but that always made me laugh. So you have to make sure that it's done right. So that's, and Ashley asked, and a bunch of people said, what's the process for this? The process is normally to just have the officer or the cell phone person read the text messages or have attorneys read it that are working on the case that know the rules, and the judge would reprimand them if they said, oh, okay, and then Karen Reed said, John, I hate you so much, or whatever. You don't want them adding some kind of inflection to these text messages. They should just be read. Karen said, well, then I dropped them off at 34 Fairview. And then read the next one, right? That's really what should happen here. So I don't find it to be a nefarious request by Hank Brennan, but the fact the defense objects should mean it's over and it's not going to happen like that. And Alan Jackson has the best argument. Judge, let's just do it exactly like we did last time when her text messages came in. And I think it was Officer Guarino read them.
All right. How are you going to find this person?
Well, we could have somebody plainclothes from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay.
May I have a moment, Your Honor?
Yes.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think Mr. Guarino, I can't remember his first name, Mr. Guarino to recite the messages from both sides. And that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial.
So I get Hank's point as far as how presentation goes. We want to present in a certain way. We feel like the evidence fits better here or there. The defense can say, then we don't object to you just continuing to call Guarino back, right? So that there are ways that you can fix this. Janet KT, woof, to exclude Chloe, wouldn't they have to say the injury was a dog bite to begin with? No, they can say, even if this was a dog, it's not Chloe. We don't believe it's a dog for X, Y, and Z. That's how they would do it. SC, thanks for the live. I learned after serving on a jury with 12 hours of readbacks, woof, there is no 1.5 times speed option in real life court. Now I love it. Yes, enjoy it. Enjoy it.
Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively we can have somebody come in.
That creates the wrong impression for you. That doesn't make sense. If the defense doesn't object to that, why are you saying it creates the wrong impression? I don't get that.
And who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time.
Oh boy, Michelle, I have thoughts. We won't have to worry about much inflection if they do that.
But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent
You notice how they just admit, like, we know these statements are coming in. We get it.
reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps,
You can't guess at their inflection or what they meant or their tone. We all have sent a text or an email or gotten one, and we're like, whoa, take it easy, bro. And it's like, oh, no, it's not at all what I meant in the text message. So it's like, so to have somebody read and try to guess what the tone was, we really don't want that in trials.
not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you.
Well, Brennan, the last comment is there will be no inflection that's inappropriate. So here's what I'll say. A couple things about this. Some good questions coming in. Why do you think Brennan wants it? So there are 2 reasons. Number one, maybe he does want it to be presented a certain way with the theatrics, but I don't think that's what it is. And he's saying that's not what it is. And he would get in trouble if that's what it was. And you could cause a mistrial, frankly, if you really put something in the inflection. But there is another reason. Timing. And if I was Brennan, I would make it more clear that, judge, this is more about timing than anything else. I don't want to have a cop get up there, 30 different times. I can have a witness that's a street clothes person or whatever, somebody we all agree on that we all know. Maybe it's a secretary in the prosecutor's office, whatever. They are just going to be there any day that I need them to be there, sitting in the courtroom. When I want to call them up to read a few text messages, they'll come up and read a few text messages because I want to present my case in a certain way and have certain text messages read after and before certain witnesses. And this, I think, is the simplest way to do it. I can understand why he would want it done that way. I think it's an appropriate objection by the defense. And I think more than anything else, what the defense is doing right here is something I do in so many of my cases. The first time there's a delay, especially in civil cases, most of what I do is, wrongful death, personal injury type cases. The defense always tries to delay. So at the first sign of delay, I'm filing a motion with the court saying, Judge, they're delaying here. If you grant this order, that's fine. We'll abide by the court's order, but they're delaying. I want to make sure the record reflects every single time they have a delay. So 25 times down the road, I can say, come on, Judge, we're here again. So the defense is making the record clear. There better be no inflection. The judge is going to make her decision, whatever it is. But if they call somebody who reads a text message a certain way that puts their own little twist on it, the defense is going to raise hell about it. And they should. And I think at the very least, that's what they're doing here. The turtle, said, hey, bud, thank you for educating us on the law. How is it legal for Brennan to consistently present blatant lies as facts to the court thus far? So I don't know if I would agree that they are blatant lies. I don't think the court would agree they are blatant lies. I would hope the court would reprimand him if he did, but I do think there's major inconsistencies and potential misrepresentations that he's making, and I think the defense has called them out, and I think he has come out and apologized for them on the record, which he should do, and which is embarrassing the more that it happens, especially when he's clutching his pearls when things don't go his way, and he's, calling names to other people that are doing similar things than he is. If not, he's doing worse things, so I would agree with you there. I don't know if I would call them blatant lies presented as facts, but because I do think, like, some of them are misstatements. Some of them are misunderstandings. Some of them he's just wrong. Like he thought he had the smoking gun, that he got something from the feds when he actually got it from the defense and then corrected himself. I'm sure that's one of the things that you're referencing. Hope, can Proctor take the Fifth since he was fired? So him being fired really has nothing to do with the Fifth Amendment. And can he take the Fifth? We are going to have a good discussion on pleading the Fifth a little later in this video. So I will save it and we'll talk about it there. Samuel L. Jackson reading the text, yes or no? As fun as that would be for us, absolutely not. This is like exactly what we can't have happen. Okay, the next thing we're going to get to is the discovery issue. ARCCA, Brennan's still not satisfied with what he has. He wants ARCCA to bring all the discovery. The defense say they have now retained ARCCA independently. So it's not just a situation where they're not retained. They're just paying them after the fact or anything like that. And the defense gives a timeline like, Judge, we retained ARCCA a couple days. It was late March, I think, when the Fed said we could retain ARCCA. We did retain them. We told the prosecution, but that opens up a lot of different things here, a lot of different options. Because I feel like we've had kind of the same fight 50 times, but it hit a little bit different today. And this is where Hank Brennan gets big mad at the defense and really is just, I believe the defense calls it righteous indignation. So let's take a listen to this exchange.
And you have that all documented, whatever information the ARCCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received in his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So
basically, very early on, the defense has been turning over everything to the feds. But Jackson makes a very specific and good distinction here that, something I said really early on when it's who is giving the direction to the ARCCA witnesses, who is providing the evidence and not providing other evidence. It's not just the defense. You can't connect that back to the defense because they're not the gatekeeper to ARCCA. They're turning over everything they have, but they are not the gatekeeper to ARCCA, and he makes that distinction here.
The Department of Justice or the U.S. Attorney's Office was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear that's not information that was then going to ARCCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCCA
Do you
to
know?
answer their questions.
Do you know what information was provided?
Yes, it's in the report. There
All
are
right,
14 categories of items that were provided to ARCCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Which is interesting, right? And that's that. If I was Brennan, I'd write that down to make sure that I can ask questions like that. I see some comments about Brennan. If you guys want to talk about the $230,000 or whatever he's made, I have thoughts on that. And we can talk about it at the end if we remember.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was providing.
All right, so when did
that's
you
what
do?
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery from the experts for their review on March 26th, 2025. That same day, the defense was provided all the additional materials to ARCCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh,
You
I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCCA on March 26th.
This is really important, this timeline, by the way, for what Brennan is going to complain about. The defense, once again, you could say, oh, they're hiding the ball, they're waiting till the last minute. It's like this case is different. The federal involvement in this case has been different since we've heard about that. I was like, whoa, that's kind of crazy. And this is why it's annoying. It's different, but the defense is just running with it. They're like, we're doing what we can. As soon as they told us we could hire him, we hired him. And now the defense has hired him, which is what the Commonwealth has been saying the whole time. Be careful what you wish for, because there are ways things change when you become someone's expert.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made.
Sometimes you can tell with Hank Brennan that he has walking up to the podium. He has made the decision to pound his fist on the table. And it's almost like he feels like he has to come with a certain kind of pizzazz when he wants to make certain arguments because he feels like it makes the argument stronger. And this was one of those times. That's for sure. Cody said, will the judge throw out the ARCCA witnesses or limit their testimony to what the Commonwealth has? Two different questions. Definitely not going to throw them out. Will she limit their testimony? Probably in some form or fashion, but how much will she limit it? I'll tell you what I think should happen based on the timeline and what's going on. Helen said, Peter, if a reader reads Proctor's text, it doesn't have the same effect. Is that what they're requesting? It's no, Karen reads text. Proctor's got to read his own text. That's his mouth. He's not a criminal defendant, right? At least not yet, not in this case. Just kidding. But no, Proctor's going to read his own text. You can't have readers come out for other people's text messages. This is for Karen Reed's text because she's probably not going to testify, and the prosecution can't call her as a witness. So they want somebody to read her text, and then John O'Keefe is no longer with us. That's why they need somebody to read his texts.
Every effort to alert the court that I had a concern, the fact that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCCA from testifying, never. But it was
Chris's comment, I would echo that. And we've been saying that the whole time. It's like, then why do you keep filing motions to exclude them? Right? I mean, he's literally tried to exclude them multiple different ways.
preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCCA. That's why I filed this motion for discovery. And when the defense responds, it's not in their possession of control. That's why these ARCCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they.
Yeah, wouldn't that have been nice? Then they lose the whole, independent argument that they get to make from ARCCA. John, I agree with the sentiment. I think we should absolutely do that and wait and see how the evidence comes in. But theoretically, you can't really do that. Nobody would be picked for a jury if you've seen what we've seen. We've seen too much and experienced too much. But I do agree with you with our discussions, and what we think is going to happen should be based on the evidence presented in this trial. 100% I agree with you. But some of our discussions will also include, oh, this isn't coming in, or this is how it went in the first trial. We'll still have some of those discussions as well. But yeah, wouldn't he be happy if they hired somebody that was not ARCCA, number one? I think that is part, I think he's kind of showing his hand a little bit. I think that's part of what he was fighting for, is for them to get somebody else other than ARCCA. But, and I don't know really when the right time is. I want to hear some more of his argument, more of Jackson's argument. But in almost every one of my disclosures for expert opinions, or when we're taking their depositions, it's always what their opinions are, and also to rebut any opinions on the other side of the experts on the other side. So it's not who gets an expert last gets the last say. It's every time you get an expert and they get an opposing expert, they're going to be able to respond and pick apart what each other says. ARCCA was not hired as an expert by the defense. Now they are. And because they are, at least part of what they're going to want to do is respond to the Commonwealth's experts. That is absolutely okay in every trial I've ever heard of. I have never heard a judge say, you can't respond to the other side's experts. And they don't give depositions here. I know he's gotten to question ARCCA multiple times, and he's still going to get to question him again before trial. But in a jurisdiction where you don't give depositions, they're going to respond and pick apart what your expert says. And some judges will allow that to be the disclosure, to be vague enough. You don't have to say exactly he's going to pick apart Dr. Welcher on this point and that point. You could say they're going to disagree with Dr. Welcher and explain why they disagree with his take, his math, his science, his methodology, whatever. And that's vague enough to where Brennan knows. I mean, everybody knows that, right? Except for Trooper Paul. I thought the Commonwealth was going to have somebody that would disagree with ARCCA, right? And maybe disprove ARCCA, but the Commonwealth didn't have that. They just had Trooper Paul. But in almost every case, when you hire an expert, they're going to respond to the other side's expert. So to try to limit them from doing that is crazy to me. That's just a bad argument. Now, they can't come up with a completely new opinion. By the way, he should already know how they want to testify about the causation of injuries because they tried to do it in the first trial. So if the judge is going to allow that, that's not really a new opinion. But he's really trying to cage them in as to what they can opine on. And you go second as the defense. They are going to be testifying after Dr. Welcher testifies. They should absolutely be able to respond to whatever the Commonwealth's experts say. Ashley said, I'm worried about ARCCA and AJ's prior communication before trial 1 when Alessi inferred and didn't know and didn't ask Alan Jackson. Doesn't seem good thoughts. So I don't know exactly what you're asking here, but that type of drawing the line, I think, is going to be very clunky if the prosecution wants to do it. Because they're not going to say feds, they're going to say independent third party, and the defense is going to try to make the distinction, I think, that somebody else hired you to do the original testing and then we retained you. I think they're just going to eat that. So I don't think Brennan's going to make it seem as nefarious, say, well, there were email communications, because that's going to be kind of weird and clunky. The jury already knows, now we've retained you, you're defense expert. But originally you were not. And I think the defense can make a cleaner cut to still try to bring in some of that unbiased nature, but still eat part of it by saying they're your expert. And now that they are, they can do additional work. Class Act Beauty. Peter, my favorite lawyer. Well, thank you. I am so happy I caught Alive. I'm always on the rewatch crew. I'm ready for this trial and all your breakdowns. Let's go. We are on our way.
They waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time.
By the way, just in keeping the timeline in order, the TUI letter was February 7th. When did they get the report? February 1st. February 1st. So within a week, they sent a TUI letter.
If they really wanted the ARCCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a TUI request. And now they're giving new information to ARCCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory.
By the way, here's one thing I would do if I was the judge. I'd be like, hey, by Friday, you got to turn over whatever extra opinions ARCCA has. If they're going to respond to the Commonwealth's expert, they've had enough time at this point. Okay. Even one day, frankly, read Welcher's report. I think Welcher's their competing expert. I don't even remember. All these expert names are going together, but give them whatever you're going to say by Friday. Okay. I think that's fair. That's fair. Put a deadline on it. But now that they're the defense witnesses, they are allowed to work more on the case, talk to the defense, help the defense prepare cross-examination questions for the Commonwealth's expert. Now that they're lock in step with the defense, which is what the Commonwealth has wanted all along, you're allowed to work more with them than when they're just the FBI experts, which is truly what I think they were throughout the entire first trial. Kyle said pronunciation of emphasis was from David Tennant making fun of his co-star Michael Sheen, saying he was classically trained actor in a TikTok. That's where I saw it anyway. Super funny clip. No, mine was like from a movie. I can't remember the movie. They literally said you put the wrong emphasis on the wrong syllable, like instead of syllable. I don't remember.
Theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the
By
expert.
the way, I loved that. He's like, we're not going to have a chance to rebut or consider somebody's opinion. It's like, yeah, that's exactly what we're doing with ARCCA. Come on.
And assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case in scheduling.
He's starting to act like he's arguing that this is a completely new expert that we didn't know about, Judge. Really? This is what you're going to do? We're going to have to change all of our witnesses around. Our order, our argument will be completely different. You know ARCCA is not going to agree with you, right? Like you already know that. You know what the bulk of their testimony is. But if they're going to also talk about why your expert's wrong, here's an idea. Why don't you just tell your expert not to be wrong? Then you don't have anything to worry about. Do math correctly. Use proper methodology, and then you're fine. Like, do you hear the defense arguing they shouldn't be able to respond to ARCCA, judge? They shouldn't be able to have a rebuttal argument and bring somebody back to say what ARCCA did wrong? That's what a trial is. To act like there's going to be no moving parts in a living, breathing thing that is a trial, I mean, no trial judge should take that seriously. We should have deadlines. It should not be trial by ambush. I do think they need to turn over whatever else they're going to testify about if it's major parts. But it's like if they say he wasn't hit by a car versus he wasn't hit by an SUV the last trial, it's like there are going to be differences. It's not going to be a rinse and repeat. There's always going to be differences.
If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7th, 2025. Your Honor, I ask you to allow ARCCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to do.
Your Honor,
Okay. Yes. View from the top, Mike Myers. Yes, that's the one. Thank you, guys. It was bothering me. I was having trouble focusing.
appears to be feigned indignation is just
There is feigned indignation, which you guys all corrected me on, which is not real.
not. Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received the report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a two-week request. We asked for a two-week permission, or asked permission to engage them through a two-week request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th.
So it's like, who's changing theories now, right? Which this is what you do. It's like you develop stuff with your experts. As long as it's not something completely off the wall, you're like, oh, he updated his report. How are we going to combat that? You know that that's what's going to happen. Like every lawyer knows that's what's going to happen. BB said, is it trial by ambush if they're repeating the testimony from trial one? Definitely not. But I do think there's going to be a little more to it than trial number one. I do. Matthew said, do you think the Commonwealth theory of this case seems slippery? Brennan seems to be unsure if they're going with a car or dog and just seeing what sticks. I think they're pretty much stuck with what they got. They got to go with the car. If they don't have the car, they lose. But I don't know. I think it's my guess. A lot of trial lawyers like this. I think he's a control freak, which a lot of lawyers are. A lot of good lawyers are. I think he's type A. I think he wants to be as prepared as he can. He wants to know. I love to know the flaws in our case. I love to know the weaknesses in our case. We've got one lawyer at our firm that looks at every case as an optimist, one lawyer that looks at it as a pessimist. I like to see both sides and listen to it and be like, okay, how am I going to deal with this? How am I going to pump this up? Because that's good for us. Brennan seems to be one that wants to know all the problems in his case, and I get that. And so he wants to know, are there any other bombshells ARCCA's going to drop? Crazy Paul said, did he just say they would change their theory based on ARCCA's testimony? It kind of feels like that. He really shouldn't. Like we already pretty much know what ARCCA is going to say. Nikki said, Canoni ruled today on the ARCCA motion to compel. She gave generous deadlines to the defense, in my opinion. Oh, interesting. Interesting. I wonder what she gave them. By the way, I have to mention this. I have to mention this because I just bring it on Twitter. For all the people that hate Judge Cannoni and say she's the worst judge of all time, most biased judge of all time, I'm calling them like I'm seeing them. When she makes a bad decision, I'm going to call her out. Today, I think multiple times she made very fair decisions, even good decisions for the defense. The dog bite teeth measurement analysis, like, thank God, that's should not come in the way they want to. She basically said, I think it's junk science. Let me see what Michelle said. The deadline's 4/1, April 1st. That means 4/18. 4/18, that is 17th is Thursday, Friday. Hey, look at that. I mean, when Judge Cannoni agrees with me, we've got to give her a round of applause, right? So I think that's fair. April 18th, that should be plenty of time for ARCCA to look at everything. If they have any additional opinions, enough time to piss Brennan off, but still allow him to prepare his opening statement and all of his order of witnesses and everything like that. I think that's a very fair deadline. And I think how she dealt with the Turtleboy issue, which is going to be at the end of the hearing, I think she did the right thing for the most part. So give her kudos when she gets them, right? Christy said, I've watched this twice and still don't get it. What is it that Brennan is saying? He said day one this would happen. I can't understand the issue. He said they were going to bring up new stuff from ARCCA, stuff they didn't turn over in discovery, wait till the last minute, middle of trial. They're going to drop new information on the Commonwealth, and that's not appropriate. He's been saying it since day one. And here we go, Judge, I was right. So again, the exact opposite of what I said before. He is laying the record. He was trying to lay the foundation in the record to say, Judge, it's going to happen, it's going to happen, it's going to happen. So when it happens, he blows a gasket. The problem for him is the timeline doesn't add up. The timeline shows the defense is moving as fast as they can. You give us something on February 1st or January 31st, we're doing something on February 7th. You give us your updated report on the end, March 20 something. We're trying to push the feds to let us hire ARCCA. They don't let us till the end of March. We hire them. It's April 16th. What do you want us to do? We're moving as fast as we can. The judge will have some decisions to make. It seems like she is going to give them some time.
So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander.
By the way, that's one of his favorite terms. It's good for the goose is good for the gander. He loves to use that.
Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done. The ink is well dried. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in judgment.
Like, that's how it works, though. Because you're kind of complaining about the same thing, right? You're complaining you're getting this information too late, which is what lawyers do, right? On both sides. That's what lawyers do. It's like, Judge, they're making my life so hard. Oh, Judge, if you let them bring this in, we're going to have to change our whole theory of the case. Oh, Judge, we're going to have to change our witness. It's like you try to make it a big deal so the judge really feels it when they make their decision. Sleuthy sent me the ARCCA, the order on ARCCA. We'll take a look at that after this section of the argument is done. Hold on to your hats, folks. We're going to go overtime tonight a little bit, so hit that like button, and we'll keep rolling here.
Welcher's PowerPoint, or by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me.
Oops. Judge, that was a misnomer. I keep saying that November date because that's when I provided his CV. And if he's arguing that they should know what he's going to testify about because they've seen his CV and what type of expert he is, he's kind of right. We generally know what they're going to say, but we still need the report. And that didn't come out until February. So he keeps saying this November date to make it feel like the defense has had longer to deal with this. But in reality, January 31st, February 1st is when the actual report came over. But he's not wrong that, like, guess what? When I have a case that's a neck surgery case and they say, here's my orthopedic spine surgeon expert on the defense, I know what that guy's going to say or what that gal is going to say. I still depose them, but they always say the same thing. Oh, it was already there before. This didn't cause it. Degeneration, even on a 17-year-old kid who was in a car accident that was total. It's like, I know what they're going to say, but I still got to hear them say it and figure out how we're going to react to it.
We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believe was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCCA. That's when we received permission to engage ARCCA. That's when we provided the individuals at ARCCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right. Thank you.
All right. So that's the end of that discussion, which is kind of the first big chunk of what we're going to listen to. And yeah, KC Cat, I don't know if I've ever seen a case where the prosecution has reacted so much to the defense. Most cases, the defense, of course, is reacting to the prosecution. In most of, civil cases, the defense is reacting to the plaintiff. It's so rare that the prosecution is doing so much reacting to what the defense is doing. Let's take a look at these orders real quick. You guys might not be able to see it. It's okay. I will read it for you. The Commonwealth moves for an order compelling the defendant to produce discovery. ARCCA Commonwealth also requests the court to order the defendant to certify its discovery obligations are complete and limit or preclude the defendant from requesting that ARCCA conduct any further review or testing. After review of the written submissions and oral argument on the motion, the court finds the following. By the way, she could have said no. She would have been wrong, but she could have said no. It is hereby ordered that by April 18th at 5 p.m., which is Friday, the defendant is to produce to the Commonwealth any outstanding discovery listed under 1, 2, and 3 of the Commonwealth's motion. 1 is all bills, invoices, contracts, retainers, engagements, letters, or payments that have been created by the defense of Karen Reed or provided to or from the Reed defense team from March 1st, 24 to the present. 2, all emails, letters, any written correspondence, including text messages, at any time between any employee of ARCCA LLC, any members of the Reed defense team, including Karen Reed. 3, all phone ledgers evidencing phone calls or text messages between any employees of ARCCA LLC and any member of the Reed defense team, including Karen Reed at any time. Okay, so that all has to be turned over by Friday at 5 p.m. In addition, by April 18th at 5 p.m., which is Friday, the defendant must disclose to the Commonwealth any oral representation agreements or understanding regarded anticipated. Let's go to page 2 here. Whoops. There we go. Way too many screens up. Reimbursements or payments on or behalf of ARCCA between any member of ARCCA and the defense team, including the defendant. It is further ordered that by April 21st at 12 p.m., which is Monday, 19th, 2020. No, is that Sunday? 16th, 17th, no, 18th. Okay, 19th, 21st is Monday. My bad. which is a holiday in Boston. It's Patriots Day. They told me that on the radio this morning. It is further ordered that by April 21st, 2025 at 12 p.m., the defendant must disclose to the Commonwealth any testing underway. Wow, this is even better than I thought. Underway, requested, or contemplated as to any testing requested, underway, or contemplated that is not yet completed, the date the testing will be completed, and the results of any testing. Whoa, that is so much better than a Friday. This is Judge Canoni has given the defense even more. It's not April 18th that you have to give them all this information, which is what I would have done. It's April 21st, and you don't even have to be done testing. Now, if you are done testing and you have information and answers from the testing, you have to turn those over. But if you're continuing to do testing, or you're even contemplating certain tests, you have to tell them on the 21st. How about that? How about that? They have till the 21st to even tell them what, is it father of the bride? Frank Bonks? Is it father of the bride then? Whatever. Sorry, I'm so confused. I'm so distracted by that. This is wild. So the defense, yeah, Hank Brennan is not going to be happy with this. Hank Brennan is not going to be happy with this. He is not. He is not at all. Huh. All right. Let's bring the hearing back up. So we have our answer. That was kind of cool timing. Thank you, Sleuthy, for sending that to me. All right. Next, we get to the internal affairs report, findings, etc. Obviously, the Commonwealth wants to keep it out. The defense wants to keep it in. And they have to take a little break after their disagreement. They talk about it and they come back with somewhat of a stipulation, which I found to be very interesting.
All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay.
So the sustained findings for Proctor, Uri, and Tully are all coming in, which is frankly even more than I thought would come in from that internal affairs report. That's bad for the Commonwealth. Again, when we talked about what I would focus on and bad cops being one of them, if you can also put up that internal affairs investigation in your opening statement, which I would, if Judge Canoni would allow it, wow. Wowza. That's not good for them. That is not good at all for them. All right, let me hit a couple questions here. Kelly, Peter, has anyone ever thought that with Karen and I hit him, etc., that maybe people around her began saying that to her where she started questioning herself? Yes, this has been a common theme that people have asked about. Is that what could have happened, etc., etc. Danette Smith, my mom has said that all my life, and I'm 64, so it came from sometime way before Mike Myers said it. Love ya, lawyer, can't wait till Tuesday. What I'm finding out, Danette, is which is so cool about having, however many thousands of people that are in here watching and talking to all of us at the same time is, seems like that might have been from more than one place. Where is Lally in all this? Backseat, he's melting into his chair, it feels like. Like this guy handled the entire trial by himself the first time. Theoretically had 8 votes for guilty on a lesser included of count 2. And he's so worthless to this team, they're not even going to have him do anything. I find that so hard to believe that that's their view of Adam Lally. But Sandy, are they allowed to bring in new evidence or discovery or stick with what they have in the first case? So only things that have been discovered and disclosed, right? They can't come up with something like today, but there has been new Sallyport video and new things that have been disclosed since the first trial. The movie is Father of the Bride with Steve Martin. The wedding coordinator was said by Martin Short. Yes, I'm a big Father of the Bride fan. Ever since I had a daughter, though, it's hard for me to watch, if I'm being completely honest. I'm not a very sappy guy, but that one's the one. Certain songs and movies now with my daughter specifically just tear my heart out. So it's tough for me. That one's a tough watch for me now, but I love me some Frank Bonks. Okay, so now we are going to get to, let's see Dobra. But what does it matter at this point? Shouldn't their theory already be rock solid? You couldn't be more correct. That's how prosecutors should prosecute a case. They should have this locked and loaded and be able to prove this case beyond a reasonable doubt, and nothing the defense does should really change their mind at this point. Really shouldn't. Okay, so the next section we're going to talk about is this whole Turtleboy being excluded from the sequestration order. Let's listen to the arguments, and then we're going to give our thoughts, as per usual. 318-ish, we have this discussion here.
Decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aiden Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are
That's a no, Judge. That's a no.
important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses.
Explain to me how he's an important witness to the third-party culprit. Is he going to say they were at the house, they weren't at the house, they did do it, they didn't do it? Or is he going to talk about, witness intimidation and that, he's the one that started pointing the finger and things like that? Because if that's what it is, the next step is very important. So what relevance does he have to what happened on January 29th?
The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
So first off, if he's talking consciousness of guilt there, right? Which if there's something in the text messages, I don't know, between Aiden Kearney and Karen Reed, where Karen Reed's like, I did it, you've got to help me get out of this. Sure. You definitely wouldn't wait till rebuttal to put that on. You'd put that on in your case in chief. So I don't think it's something like that. So some very vague potential ways that you would call Turtleboy to the stand. That's Aiden Kearney. Is it Kearney or Kearney? I always say it wrong initially, so I tried to change it. I think I usually say Kearney, and it's actually Kearney. But Brennan saying Kearney now is throwing me off. That I'll just tell you, as a lawyer, that sounds like you're not going to call a witness. And this has happened to me before, where lawyers have put people on the witness list for different reasons. But you can usually tell when they're going to call somebody and they're not going to call somebody. And I can tell by him saying that they ain't going to call him. I really don't think they're going to call him.
Okay. All right. Now I'll hear you, Mr. Bradle.
All right. Thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask if
I like how this lawyer's like, Judge, I'm just going to lay it all out there for you. Let's stop playing games and let's cut to the chase. They're not calling him. And I tend to agree with him. He's like, well, how can you be so confident? You don't know. They might call. You can only call relevant witnesses, right? You can't call Turtleboy and put up his Twitter and be like, here are some nasty things you've said. You can't do that in the Karen Reed case. It doesn't prove whether or not she committed the crime. You can't say, look at all these people that hate you. You just, that's not relevant to this case. So that's what we know, what can come in and what isn't going to come in at trial. And he doesn't have any relevant information, except for potentially what he has done or said to some potential witnesses in this case. So hold that thought, but nothing factually about what happened on January 29th. Thank you, Chris. And McRae.
if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement, what we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness
Okay,
intimidation.
so just focus back on,
Okay, so that brings in our second big chunk here. And that is, can Turtleboy plead the fifth? Before we get there, Ashley said, dumb question. What's an offer of proof? It's a proffer offer of proof. It is where lawyers can say what they expect to happen or what they expect a witness to testify. Usually you're laying the record. You're saying like, Judge, you're not letting me call Miss Jones. We believe Miss Jones would take the stand and say, you know, Karen Reed was never in the Lexus, never owned a Lexus. And the judge's like, okay, I'm not going to let you call her. But now you have that on the record. You put out there what you believe to have been testified to. So in this situation, I believe what this lawyer is referencing is he didn't even tell us what he expects to get out of Turtleboy. Like, what are you going to ask him? I literally almost just called him Dr. Turtleboy. I think does he have his doctorate? I don't know why I was going to call him Dr. Turtleboy, which would be hilarious if like Brennan actually called him Dr. Turtleboy in court. But like, if you were going to put him on the stand, and I love him or hate him, right? Which there's plenty of people that love him, plenty of people that hate him. And I totally understand where people are coming from on this argument. He puts himself out there. He is a certain way about him that is going to rub people the wrong way. Not the way I like to talk about people or talk to people or handle situations, right? But he's definitely been covering the case. And that's important with this because we have a First Amendment right. We want journalists. We want people covering the case. We want people getting information out there. That's something we care about in America. You don't have to listen to him. You don't have to watch him. You don't have to get your news from him. But if you do, and that's gone, and that was your only resource to this case, that's a problem for you, right? And we don't want to cut that type of stuff off. But regardless, this could be John Smith, and I'd be feeling the same exact way about it, okay? And you should too, if it was John Smith. That's a real test for yourself. Like I said, I'm testing myself with the Lori Vallow case and how I feel about her personally. Test yourself with the Turtleboy case and how you feel about him. If you really don't like him, do you care about the Constitution? Because it's not just our First Amendment right. So anyways, what I think was going to happen is he wanted Brennan to say, Judge, here's my offer of proof. We think we can call Turtleboy and he can testify to X, Y, and Z. And that's why it's relevant to this case. And that's why we might call him. And that just didn't happen. So Nikki, Turtleboy's lawyers believe they just want to keep him out of the courtroom. They just want to keep him from threatening them. He just wants to keep them from, oh gosh, people are saying his doctor's preferred pronoun. So I probably just did a thing on the internet now. But anyways, that's what they think. They want to scare him or whatever. There's all these like other underlying, not really appropriate reasons to put somebody on a witness list to sequester him and keep him out of the courtroom. That's why you would put somebody potentially on a witness list. Was there something else I was going for? Oh yeah. Okay. So now we're going to talk about for a second, the Fifth Amendment, another constitutional right. That's very important here that we should, apply to this case and be very protective of. Your Fifth Amendment right is to not be forced to incriminate yourself, which means this goes hand in hand with the government having to prove beyond reasonable doubt that you committed a crime. And they should do it without you telling them you did it, right? That's part of the process, or without you telling them anything, because we know how people's words have been twisted against them, how people have been interrogated improperly, or maybe abused in how they're kept and held. And then eventually they say something that is used against them. Okay. So from my perspective, if the only relevance we could ever think of for Turtleboy in this case is something to do with the witnesses, number one, and he literally is being prosecuted, what he says in this trial could and would be used against him in those other prosecutions. So this is like the most perfect way to plead the fifth. He absolutely should. Any lawyer, I was going to say any reasonable lawyer, but I think any lawyer, even unreasonable lawyers, would advise him to plead the fifth in this scenario. Now, can Proctor plead the fifth, right? Where people were asking that. Proctor doesn't have any charges against him. Proctor said some horrible things. What he said got him fired. Makes him look like a douche. But it's not a crime. Calling Karen Reed those names, not a crime. Now, a cover-up and conspiracy and fraud and things like that, if he's worried about getting prosecuted for that, then sure, he can plead the fifth. But there has to be a reasonable fear of criminal prosecution, and what you say has to reasonably be believed to be incriminating or potentially incriminating. Sometimes we might not know, right? It's like, Mr. Proctor, what did you do when you drove home? It's like, well, you know, I'm not even going to say this, right? Let's say he committed a crime on his way home from talking to a witness in Karen Reed's case. Then he can be like, I plead the fifth. If I answered that, I would potentially incriminate myself. Okay. The judge may have another discussion and be like, okay, yes, you can. Yes, you can't, off the record, whatever. There is something, judge, has nothing to do with this case, that I can't say what I did. It's not relevant to this case, whatever. We're getting into the weeds. But the point is, he is not in fear of incriminating himself with the statements he would make in the investigation in this case. But Turtleboy, on the other hand, has a criminal case against him. Another thing. Well, let's watch, because there's something else that happens here. And I think there's a reason behind it.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was, I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney, will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and
that's what everybody figured would happen until he was on the witness list. And of course, he wasn't in the list of people that would be exempt from the rule of sequestration. We read a similar argument as far as the journalism aspect with Voss, Gretchen Voss, I think, from the other motion file. And that's true, and that's important. People can poo-poo that all they want, but that right is really important.
And, I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he...
What procedures exactly? I kind of wanted to hear him say that. So if you know a witness, you can't call a witness just to plead the fifth and then make him look bad about it and use it against him here in Massachusetts. So you're not calling him. Like that's the real truth. That you know the answer there, but he doesn't stop there.
Actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But as a predicate, he would need to assert his fifth.
Do you need that to
As a predicate, he would need to assert his fifth.
be done formally, or do
Yes.
you want it to be?
Do you need that to be done formally? So, John, I've been holding this comment. She had no choice on Turtleboy. She did, because she even asked Brennan, which I think is weird because I've never seen anybody have to actually get up on the stand and say, I plead the fifth, when you're not actually testifying or being asked the questions. Having your lawyer assert it for you is completely appropriate legally in every jurisdiction I've ever practiced in. I've never practiced in front of Judge Cannoni, so it would be weird, but theoretically, she could have made him sit there on the stand and say, I plead the fifth. Will she do that? Let's listen, because Brennan wants it to happen. He wants Turtleboy to sit his butt up on that witness stand and say, I plead the fifth, and I'll tell you why in a second.
Be done formally.
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation if he wants to assert the Fifth Amendment privilege.
We would reject that invitation, and I didn't notice the first time, but this is Turtleboy right here, and I think he's loving every second of this probably. But Brennan's like, he's like, I invite you to accept this. We reject that invitation. It's like they're trying to use polite verbiage, but it's really kind of a battle here, a battle of egos of how is this going to go down. And there's no other way to say it, but it feels like Hank Brennan wants his pound of flesh. He wants the cameras. He wants the YouTubes. He wants the clips, the GIFs, the whatever, the GIFs, if you call them GIFs. You'd be wrong, I think. But he wants Turtleboy sitting up there on the stand saying, I plead the fifth, because then the world will go crazy about anybody who pleads the fifth is guilty, which is wrong. Anybody who asks for a lawyer is guilty, which is wrong. Anybody who hires a lawyer is guilty. It's wrong. And I'm saying that facetiously, that's what everybody would say, but for so long, so many people have thought that, and it's just wrong. And I will take every opportunity I can and have with this platform. That is one of the things I think that can positively come from this platform, is to help us all understand this process and not jump to that conclusion. Just because somebody pleads the fifth, just because somebody doesn't talk to cops, just because somebody hires a lawyer, does not mean they're guilty. Doesn't mean they committed a crime. It doesn't. It never will. Now, a lot of people that hire lawyers, a lot of people that plead the fifth are guilty. If they're proven to be so, or they plead guilty, or they admit it, or whatever it may be. But it's one of those, like, you know, what are those diagrams where it's like two circles? It's like, here are all the people that hire lawyers. Here are all the guilty people. And it's like this, right? There are some people in the middle of that circle. This is the worst explanation of all time. I wish I had my board here to write on. But it's like all these people that hire lawyers and all these people that commit crimes. Sure, there's some crossover, but there's definitely some room in the circle for people that hire lawyers and plead the fifth that did not commit a crime. And I'm not making any assumptions about whether Turtleboy did commit a crime or did not. Like I said, same analysis as if this was John Smith. Ben said, Peter loving on Turtleboy is hilarious. He should listen to what Aiden have said about him. I literally don't care. I've heard what he said about plenty of people. Nothing he would say about me would ever surprise me, right? I'm sure he has ripped me to shreds. That wouldn't surprise me one iota. Not at all. And frankly, have at it. That's his shtick. That's what he does, right? Go ahead. I think there's plenty I say that he couldn't argue with, right? And here's the other thing. That's not going to make me change what I say about this. Like, haven't you guys figured that out yet? He could say I'm the worst, dumbest, fake lawyer in the world. I don't even have my law degree. I'm an idiot. Why does anybody watch me? And I will still say the same thing about this process. This was the absolute right move to plead the fifth. I care about his constitutional rights. Frankly, if he talks bad about me, this makes this even better. It literally makes it even better. So kudos. Like that doesn't bother. That's what I'm trying to tell you. It's the same way Brian Steele going from everybody's favorite lawyer when he won the case-ish for Young Thug. And now that Diddy hired him, everybody's like, uh-oh, what do I do? It's like, this is what lawyers do. Criminal defense lawyers represent people accused of crimes. And that's where Diddy is. Now, I got my thoughts and feelings on how I think that case is going to go. Doing my best to put those to the side. I see people saying Turtleboy likes me. That's great too. That's great too. I don't know him personally, so I don't know how he would like me, but hopefully respects me or doesn't think I'm an idiot. Right? I don't want him to think I'm an idiot. I don't want anybody to think I'm an idiot, but there are plenty of people who do. He wouldn't be the first person to call me an idiot, okay? But I'm trying to illustrate a point, okay? I'm trying to illustrate a point. And the point is, for the worst people in the world, whoever you think that is, whether you think it's me, Lori Vallow, P. Diddy, Turtleboy, whoever, or anybody else, their rights matter. We have to fight for their rights, because then all those people that think Karen Reed is not guilty, that's the only way and world in which we can continue to try to keep the playing field as level as possible. Okay, so let's see if this, I want to call it grandstanding, but let's see if he gets his pound of flesh, right? Let's see if he gets his pound of flesh and gets Turtleboy up there. Honestly, like, I don't want to compare him to a rather large figure, but there are certain people, I would just say, that love their mugshots, that love potentially this moment of getting up there and pleading the fifth and looking Hank Brennan in the eye. I think Turtleboy would have probably been perfectly fine with that too, but it seems like he's smart enough to listen to his lawyers. You should listen to your lawyers. That's another teachable moment that I'm coming with here. All right, let's keep listening.
He can assert it.
Okay. Do you want to call him now to be done formally,
Polite exchange again.
or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody's there. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
I think he has a Fifth Amendment privilege.
Court is back in session. You may be seated.
Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but
And that's why the proffer, because it's almost like one of these, I had a cousin who would always be like, oh, I know that. I can't tell you how, but I know that. And I was like, oh, you're so annoying. So it's like, well, there may be some questions, Judge. We may call this witness for this. It's like, that's not how this works. Like, tell us, what is it? What question would you ask him that would not be incriminating? Because let's get to the bottom of it if it really wouldn't be.
content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing.
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
Judge is like, this is not really a conversation. Like, are we being serious here? Like, you guys are prosecuting him and you're not going to say he's got a Fifth Amendment right?
Please allow me to make the representation on behalf of Mr. Carney that he would in fact invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Kearney to assert his Fifth.
Oh, I thought you wanted to base.
It's like the seventh time. It's like, Judge, and by the way, Brandel seemed like he might be okay with it at first. Then he's like, you know what? No way. Why am I doing this? No, we're not going to give him this shot in front of the cameras. And the judge like asked another question. She's like, no. I realize you guys are. She's like, is there any objection? Because it almost sounded like they agreed on it. And Brennan again had to stand up and say, no, Judge, I would like him to take the stand. I would like him to plead the Fifth.
No, I'm going to see Mr. Kearney here at Sidebar with just you, Mr. Bradel. And all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
All right. So now they go up to a sidebar. Turtleboy and Brandel, they turn off all the recording devices. They're not writing down whatever is said at sidebar. So here's where the judge is going to talk to Turtleboy, talk to his lawyer, say whatever they said. I'm not even going to guess, right? Because it was up at sidebar. We're not supposed to even know, but we do know that she comes with her decision afterwards.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
I accept those findings. It's like, well, thank you, Mr. Brennan. It was not a good day for Mr. Brennan. And I go, and I think he has had good days. And I think he'll have some good moments in the trial, but this was not a good day for Hank Brennan. It's like you really put yourself out there to get your pound of flesh, to get your moment. And everybody's like, whoa, what are we? That's not what we're here for. That's not what these taxpayer dollars are going for. And after talking to the judge at sidebar with just Turtleboy and his lawyer, The judge is like, I find that's all appropriate. I'll accept it. He's pleading the fifth. He's not going to come up here and take the stand. It's not great for Hank Brennan. Stephanie, what happened with the text between Karen Reed and Turtleboy that the Commonwealth asked for? They got some texts. They didn't get others. Doesn't seem like there's anything that's going to be relevant that's coming out of trial. Noel, I'm behind, but what happens when they don't turn over what Hank thinks is available via discovery on Friday? Like they said in court, the judge, they have provided everything thus far. Well, if something exists that they don't turn over that they should have, that's going to be a problem for the defense. But if Hank Brennan just says something exists and the defense says it doesn't and it never comes out, then it doesn't exist. How come Gretchen Voss was allowed to not be sequestered while on the jury list and she is a journalist, but Turtleboy, same situation? Well, the defense conceded, I shouldn't say conceded, they stipulated and agreed that the Commonwealth is not going to have to call Gretchen Voss to authenticate those interviews with Karen Reed. They can just play those interviews with Karen Reed. So because the defense did that, Gretchen Voss was never going to be a necessary witness. Proctor could be charged with perjury, tampering, though. You don't plead the fifth during your testimony if you're perjuring yourself, usually. But sure, if there's some kind of tampering or conspiracy or cover-up fraud, yeah, like I said, I don't think that he's going to plead the fifth for those reasons. Why would Brennan have that stance as a defense attorney? I'm surprised how anti he is against her rights. I don't know. It's interesting. Levain said you have to have thick skin. Oh boy. The thickest in these parts. Katie, late joining. Do you have your red Solo cup tonight? Sure do. Water's ice cold. Peter, could I sit for the bar after 7 years of lawyer apprenticeship a la Abraham Lincoln style? I mean, I think we should start a movement and see if we can get that. Maybe like in Puerto Rico or something, right? Maybe not in Florida, but maybe somewhere. Patio said he respects you. I assume you're talking about Turtleboy. That's good. I appreciate that. Anybody who does. I appreciate anybody who does. Like, it shouldn't be a surprise to you guys how I feel about Turtleboy, right? Like, it's what I try to go in thinking about every single person and how they are, give as much grace as I possibly can because I know I need it. Tammy Lynn, Peter, Turtleboy just extended an invitation for you to be on his show to talk about the Karen Reed case. Would you do it? Terry said, I'm here because Turtleboy name dropped you just now. He wants you to come on. I have a thought on this. Let me see. B and BOG, Turtleboy likes you. I think he just wishes you would come out and say Karen Reed is innocent, LOL, because she is. We know you keep it fair and balanced. There's a lot of people that wish I would say a lot of things, and I understand why, and I get it. And in this same vein, okay, I'm not going to go on Turtleboy's show right now. First off, tonight I'm dead tired. I need to close this thing up. But generally speaking, I think that it is better for the analysis and coverage of the case, from my perspective, to not go on Turtleboy's show at this point. Maybe after the trial's over, we could talk about it. We could say, hey, what went well, what didn't, whatever. But from my perspective, I am trying my best to call everything like I see it, to have the discussions in my own head as kind of a lawyer, to look at the case objectively as possible, right? Turtleboy is in a camp, right? And he has his own charges and his own things that he's dealing with in this case. He feels very strongly. He knows a lot more than I do factually behind the scenes. He's talked to way more people, met way more people involved in this case, knows witnesses, knows officers, knows attorneys, knows the clients in the case, right? So he has his angle. He brings what he brings. Mine is something very different. And I think eventually maybe that conversation can happen. But I think honestly, it would be better for everybody listening and have more of an impact on how we both feel separately about the case. For right now, for us to just keep running it as we're running it. And that doesn't mean that I hate him. That doesn't mean that, I'll never speak to him or, I think he's, the worst of the worst or whatever. Like that. That's not what I'm saying. That also doesn't mean I think that he didn't commit the crime. I haven't looked at the statute. It seems a little rough. I talked to Bedero about it for a little bit off the record, just about the statute, but that's another conversation for another day. I think he is covering this case the way that he's covered this case for a long time. I think he's made a lot of headway. I think a lot of people know about this case because of the way he's covered it. And I just think right now to focus on the legalities, the lawyering, the judges in this case, that I'm going to continue to run the ship forward the way that I am. But eventually I think I would like to Either have him on mine or go on his. I think eventually I will go on his show and talk to him about it. I think it would be interesting. Thanks for the overtime, Peter. This is my favorite Lawyer You Know live. Well, that's random. Mr. Brennan, tell your expert not to be wrong, quote unquote. Okay. Here we go. We're ramping up for the Karen Reed trial. I hope everybody hit the like button if this was one of your favorite lives. Kelly, would Turtleboy pleading the fifth be able to use against him in his trial? No. No. Welcome to all the new members tonight. They're paying more for Brennan than they spent on the audit. That's awful in my opinion. Thank you, Lawyer You Know, for sharing your knowledge. So let me talk about the Brennan money for just a second. Okay. $230,000. Not unreasonable for a defense lawyer on a case like this. $234,000. Not enough to me to quote if you were a defense attorney for a case like this. $234,000. Most big time defense attorneys that are going to bill hourly would bill more than $230,000. All of that being said, right? Because that's my stance on it. And we've quoted a lot of fees and we've handled cases that are very expensive and people would be like, holy crap. That's a lot of money. That's unfair, whatever. So the problem is, and the reason it feels outrageous is he's not a defense attorney in this case. He's a prosecutor. And that's more than I think any prosecutor makes in that office. And this is additional money that they're paying all the prosecutors that already work in that office. So maybe that's why Lally's pissed off. Maybe that's why Lally is sitting over there, doesn't want to work on the case. From my perspective, I think that's inappropriate. And that's somebody who thinks lawyers should be able to make as much money as they want to make, right? Obviously, that's the chair I'm in. But we all know that's kind of part of being a public servant. As a prosecutor, as a judge, as a public defender, from my perspective, that's part of what comes with it. So to bring this guy in, pay him all this money, to me, I understand why people think it's inappropriate. Now, I think prosecutors should get paid more. I think public defenders should get paid more. But with how it is personally or right now currently set up, I think that's a problem. And if I was a citizen of that jurisdiction, I would want some answers about that. I would want some answers about that. You guys let me know if you agree or disagree. Okay, let's see here. We got a couple more. Peter, losing respect for you tonight. Turtleboy does not have all this knowledge. He's a known harasser. And this is the thing people have to understand. Like Ben, and I actually, Ben, I recognize your face. I know that you've said stuff like this before. And that's okay if you feel that way. I also am of the mind that I think you can talk to people you agree with. You can talk to people you disagree with. You can talk to people that are good. You can talk to people that are bad. You can learn from people. And that's all kind of part of our process. Now, he might be convicted of a crime and he might become a criminal. Guess what? I've talked to other people who have been convicted of crimes and are criminals. I have friends that have been convicted of crimes. I've become friends with clients that are criminals that have done bad things and turned their lives around, right? There's just, I don't like to draw a line in the sand, cross people in or out. And again, that's not, you guys know my style. I think me and Turtleboy styles are very different, right? I don't think that we handle things the same way or see things the same way. And that's okay. That's okay. I will lose all respect for you if you go on Turtleboy's show. This has nothing to do with her guilt or innocence. His behavior is appalling, abusive, and disgusting. I understand that. And everybody has to make their own individual decisions, right? And everybody is going to continue to make their own individual decisions and do what they think is right, right? And I understand that. I don't live in fear or handle my channel in fear that, you know, I'm going to go on one channel one day and somebody's going to be like, that's where I crossed the line. And it's like, I understand that. I'm going to be me and I'm going to speak like me on anybody's channel. And maybe it'll have a positive effect on somebody or their channel. Maybe it will. Maybe it won't, right? Maybe it won't. And I don't know what I'm going to do, but I know whatever decision I make is going to be because I think it's the right thing to do. Right? Like that's what I'm going to do. And I don't know what that decision is going to be made. It was going to be. I know what it is right now, and I know what it is through the trial. And we'll see where it goes from there. Life is a living, breathing thing. It's always changing. We're always growing. We're always learning. We're always trying to get better. And I will always continue to do that. And I'm fine with you guys holding me accountable for it too. I want you to. I want to know what you think. Peter, come give a CLE at my firm. Some people might actually pay attention. Smitty, hit me up. Send me an email. Would you have Brandel on your podcast? Thank you. Yeah. He seems like a really smart guy. And I always like appreciate having lawyers on, because most lawyers, you have to pass the bar. You have to be in good standing. You have to take ethics. And there's a certain line now, you can laugh at that and say, some lawyers are total scumbags. And I get that. But I like having lawyers on because there is a certain level of seeing eye to eye with them on certain things and understanding that we should start at the same spot, that we care about the laws, we care about the Constitution, we care about people's rights. Let's see. Peter, do you know Lori V has $2 million life insurance? We needed that moment of levity, Chris. Thank you. Lally's salary is $149K annually. Yeah, I mean, I get it. I get it. Right? I get it. BB&G, Ben is wrong. Love you, Peter. So I don't want to hate on Ben. Ben, thank you for being in there. Thank you for your comments. I get it. And I'm not saying you're hating on Ben, but people have opinions, and I understand that they have opinions. I understand they have opinions. I get it. And everybody's entitled to their opinions. And I appreciate Ben being here. I'd love to have his interaction going forward, answer his questions, see how he thinks about things. That's cool. I hope he stays. If he doesn't, I understand as well. Peter, I've been following you for a while. I respect your honesty and your opinion. Thank you. Thank you, Sharon. I appreciate it. And Jen, so excited. Thank you for the gifted membership. That's awesome, Jen. All right. We got to wind it up. Pantuffle, no idea if Karen Reed did it, and neither do any of you because we weren't there and the investigation was so awful. So they can't prove anything either way beyond a reasonable doubt. Not guilty verdict is not necessarily innocent, right? JO was failed. Not guilty verdict is innocent or not proven. That's what I should do. If anybody asks, oh, it's Bradel, not Brandel. Okay, that's my bad. You know what? Like when you see something in your head the first time and that's how you pronounce it, that's just kind of what sticks with you. That's what happened. Plead the fifth, Peter. Yeah, I plead the fifth. And that's why you have my respect. You are, regardless of so many opinions flying around. And that's always how it's going to be. It's always how it's going to be. And that's okay. That's okay. It's what makes America great. All right. I'm out of here. Hit the like button before you go. Till next time, peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.